Welcome to the Ninth Amendment Party, the South Carolina chapter. All information is verifiable. United States codes, Code of Federal Regulations, Bouvier's dictionaries, Black Law dictionaries, the Universal Commercial Code, and congressional records. The Ninth Amendment is the People's Amendment. It allows the people to actually control the state instead of the state controlling the people. The Ninth Amendment Party is an unincorporated nonprofit association. There are three classes of people: those who see when they are shown, and those who do not see. You can find all of our relevant information at the ninthamendmentparty.com. I cannot teach anybody anything. I can only make them think. Socrates. We're not here to cause havoc, stress, slander. We're here to bring the information that's all verifiable. When we look at our life here in the United States of America, we all think the wars have always been fought abroad, when in actuality, the war that we are fighting is within our own country. What we're about to share is evidence, factual evidence, verifiable evidence to you, the general population of South Carolina, to each and every one of you who are running for public office, to those who are enforcers of color of law. We are here to bring this understanding of truth, that we are not a corporate democracy or a banana republic. We are a true republic form of government, one of the people, for the people. The term sovereign citizen, when used by judges, sheriffs, state police, city police, and elected officials, they can actually create a liability due to slander and violations of due process. On page 1, we have the General Memorandum of Law, misuse of the word sovereign citizen in federal courts. Misuse of the term sovereign citizen is a sanctionable, prejudicial, and defamatory violation of judicial standards, due process, and ethical conduct. On page 1, we have the introduction. On page 2, we have case law. As we look on page 3, the label sovereign citizen is a weaponized slur and constitutes defamation per se in legal context. It violates court rules, it disrespects the Constitution, and it invites swift sanction under Rule 1 and Section 1927. As we look at page 4, it's weaponized misconduct by the judge, by anybody who utilizes that to put you in a category. Using sovereign citizen is a sanctionable violation under Rule 11 and 28 U.S. Code, Section 1927. When we look at page 5, we have different rules as well as evidence that shows it is not to be used to create bias. On page 6, the conclusion: strike the slur, defend due process, judicial impartiality, constitutional due process, rules of ethics, factual integrity in pleadings, a fair trial rights. Courts must strike all such references from the record. Admonish and sanction any party, counsel, using it without factual foundation. Preserve judicial neutrality by focusing on verified facts and controlling law, not labels. 7, protect litigants from defamatory rhetoric that endangers their fundamental rights. Justice is not served by a smear, it is served by fact, law, and fairness. When we look at page 7, this term sovereign citizen has been weaponized by law enforcement agencies, government watchdog groups, and political actors as a catch-all label for anti-government hostility, tax evasion, domestic terrorism, and judicial disruption. Its functionality is equivalent to calling a party a militant and a seditionist, or a threat to the state, without evidence, without hearing, and without the constitutional guarantees afforded to the accused. Labeling a party as a sovereign citizen is not merely improper, it is reckless and a malicious act. It is a form of courtroom defamation executed under color of law that irreversibly stains the record and compromises the impartiality of the judiciary. It discredits legitimate arguments, not by rebuttal, but by smear. It preempts due process, not by law, but by label. It stigmatizes not by truth, but by tactical insinuation. Here in South Carolina, slander falls under the broader category of defamation, which includes false statements that harm a person's reputation. When an inflammatory statement is spoken rather than written, it is classified as a slandered, unlike liable, which involves written or public statement. Slander requires proof that the false statement was spoken to a third party and caused actual harm, because verbal statements are fleeting, providing slander can be more challenging. For the statement to be considered slanderous, it must be demonstrated false and communicated to someone other than the person being defamed. Truth is an absolute defense if a statement is factual and accurate. It cannot be considered slander. Additionally, the statement must cause reputational harm that can be substantiated, plain and showing actual damages, such as a loss of employment or diminished standing in the community. When we look at life, and I've been teaching this for over 40 years, I have had slander brought forth by many individuals within the political arena, the enforcement arena, as well as just general people in the population of the communities that I have been taught and also been teaching in. Certain statements are considered so inheriting damaging that they are classified as slander per se. In these cases, the plaintiff does not need to prove actual damages. South Carolina law recognizes a slander per se, and accusations of criminal activity, allegations, etc., can actually harm individuals. What you need to know is what I teach. What you want to hear depends on your ego, depends on your fear, depends on your stance with government. What are you willing to do? The province of jurisprudence determined. We all have a duty to God and lower animals. We have a duty of self-regarding, responsibility. We have a duty to our community, to those in need and to those who are not. Duty to our sovereign state and country. The protection of the individual rights that you and I both share are God-given rights, unalienable rights, or unalienable rights, as I like to say. Remember, we are created in God's image. We live in one country versus two nations. The people's options are by consent. We either live in a constitutional republic, such as Sustainable, 1776, or like presently, we live in a corporate democracy since 1871, since the official act, unsustainable. There are three original founding documents: the Declaration of Independence, the Constitution of the United States of America, and the Bill of Rights. The Declaration of Independence was one of our very first written statements that brought our country to a new era and a new time frame. We have the Bill of Rights and the Constitution. The Constitution lays out the framework. The Bill of Rights, Amendments 1 through 10, are very important to understand because those are our foundation and our principles of what this country was determined to create. Did you know that South Carolina had a sovereign flag? Do the elected officials understand their role to protect a republic form of government? The absolute truth. The 50 United States under a republic form of government, laws of nature and nature's God, we the people, construction of general laws that don't violate the Constitution, government of the United States, 50 states, public servants, we are here to serve you. Enacting and enforcing general laws by judicial due process of law, i.e., innocent till proven guilty. The supreme law of the land must be an injury. Our Constitution of the United States of America is the law of the land. Current examples: judges, sheriffs, city police, tax assessors, and code enforcers. All are considered policy enforcers. They work under Admiralty Maritime, the law of the sea. It's an incorporated office. The corporate powers, private contracts, dishonor of the public oath, full commercial liability, law enforcement officers collecting revenue for the corporation through contracts. You are an artificial legal person. While acting as a person, you're under contract, obliged to perform according to the terms and conditions of statutes, rules, and regulations. Only a legal person, or can be a corporation, can be taken to court for any offense. The penalties, again, are statutory for the legal person. Since 1967, there are no current examples of a peace officer under common law, the law of the land, non-incorporated office. When we look at everything that has taken place since 1967, we have actually lost the justice of the peace. They became a magistrate judge. The sheriff became a full commercial sheriff, generating revenue for the corporation, not protecting your rights. We had rights of the people, by the people, and for the people. The officer must have probable cause and articulate reasonable suspicion that you are committing or about to commit a crime or harm a living soul. While a living soul, you are in the common law obliged not to cause harm to other living souls or their property. Only if there is a victim is there a true crime. That's the only way an officer can establish jurisdiction over you. Think about what takes place today. The United States of America is one of the largest populations within the prison systems, all dealing with policy officers, commercial statutes, etc. In what capacity do you act as an elected official? Do you serve the legitimate de jure constitutional republic, or are you bound to the federal contract and terms of the commercial democracy? Which jurisdiction are you operating in? Organized, municipality, or the corporate? When we look at these three areas, the writing of each and every aspect of life changes as the jurisdiction changes. On the organized side, if you notice everything in upper and lower case. In the municipal aspect, it changes. The municipal works in both the constitutional aspect as well as the incorporated. However, the incorporated does not compete with general businesses that you and I, the men and women of the community, have. Unlike today, a full corporate state of South Carolina, a full corporate Hampton County, a full corporate city of Hampton, you have no rights. You're under servitude. The municipality gives you some rights. However, if we return back to the organized constitutional perspective, we have all our rights, the unalienable rights that God has given us.
My name is BT. I come from northern New Mexico and I'm American Indian. And I want you to know that I've experienced socialism. Our family has firsthand. We were the first socialist program in the United States being placed on reservations. I come to you today with an open heart. And I want you to understand that there are two forms of government right in front of us. We have Collier County, the corporation, and we have the municipality, which works in constitutional and in corporate. What we're here today to discuss is the Constitution, the reality. I was educated by the first constitutional sheriff in the United States, according to Paul Harvey. My father kicked out all the federal agencies in his county of northern New Mexico. So we've talked about federalism and federal here today. But let's define what the term federal means. Some of you have handed out books, but on page 9, the definition is this: federal, pertaining to a league or treaty derived from an agreement, a covenant between parties, especially between nations, constituted by compact between parties. So it's pertaining to a league. So let's look what the league definition is. League, criminal law, contracts, In criminal law, a league is a conspiracy to do an unlawful act. Think about that. So what is conspiracy? Conspiracy is an agreement or an engagement of persons to cooperate in accomplishing some unlawful purpose or to do any act with the intent to prevent the course of justice or to effect a legal purpose with a corrupt intent or by improper means. So the federal government was pretty much right on when they told us what they were going to do. They were going to conspire to take our rights away. The federal government existed in 1871 through the act when the United States became a full corporation, just as Collier County, if you look here in front of us, is representing, all in capital letters. I've lived and experienced both areas of government, both the constitutional side as well as the corporate side. We live in a society of individual consent according to the statutes under color of law within every state. You have to have consent. We are a constitutional republic where unless there is a true injured party, there is no law broken, and not a democracy governed by corporations, structures, under the presumption, rules and policy, mandates and ordinances which violate the United States Constitution through compact, as well as the state of Florida's Constitution. What is a full corporate county? It's a mere governmental agency known as a political subdivision under corporation status, just like McDonald's. Outside of the municipality of government, there's no constitutional protection of your God-given rights while providing services while they compete with business. So what is a municipal corporation? It's a corporation of the inhabitants, a special region such as Collier County, for the purpose of local government as a distinct entity and not connected to a political subdivision. In other words, it's not a full corporation demanding our rights the way they seem to fit. When we look at ordinances, ordinances are not law. They're corporate bylaws. Did any of you know that? This is supported by case law as well as jurisdictional principles. So I ask you, the county commissioners, today, on the record, which jurisdiction are you at today? Are you a constitutional elected officer? Or are you an agent, principal agent of the corporation? Who are we addressing? Do you know why we don't have rights? The reason I ask this is that everybody knows that only one game can be played on the field. You can't play baseball on a basketball field on the same time. So again, which area are you at? Are you under the true municipality of constitutional protection, or are you ruling us today through the corporate status in all cap letters of Collier County? The continuation of unlawful and illegal acts within our county and failure to disclose contractual agreements happens daily here in Collier County, as well as the other 3,000 plus counties in the United States. Here locally, when we look at some of the contractual agreements, if you own a home and you're under the Homestead Act, the domicile that they place you in actually puts you into the corporate structure outside of the constitutional protection of owning property outright. Think about that. That's what's taking place, not just here in Collier County, but around the United States. This ordinance is just like others that are brought forth under the definition of terms. When you look at the ordinance, the top section of the ordinance is in all capital letters. There's a reason for that, because that's how the corporate spelling is done for laws within that status. So in layman terms, we, the inhabitants of this community, are addressing the corporate system as stockholders and not free, constitutionally protected living beings created by God. This is due to the presumption of your corporate name. So I ask all of you, Pull out your driver's license. Look how your name is spelled. Look how everything you get from the corporations are in all capital letters. That means you are a corporation according to the Administrative Procedure Act within most of the United States. Some people actually bring it out. Others hide it because they don't want you to know that you're actually considered a corporation. So today, we ask this community, these county commissioners, again, are you going to protect your oath of office? Or are you going to just pass a bylaw or say no to a bylaw? We, the people of the county, are asking for our constitutional Bill of Rights. We shouldn't have to ask it under an ordinance, but since we are operating as a commercial entity, quasi in rem, we have to do this to be able to protect our rights. I've witnessed personally the most ridiculous statements on both sides of this situation, some good and some bad. Most people don't understand the standing in courts. Not one person in here has standing in courts except myself and my partner. And that's proven because we've been in the court system many times, won many times, and I've lost a few times. That's because of corruption through the interpretive rulemaking that corporations are allowed. So when I ask you to look at the future, it isn't so much the county commissioners that we have to worry about. We have to worry about the sheriff. Will the sheriff take control of the sheriff's office and stop utilizing it as a corporation for rules and mandates and violations? We have to look at the county clerk. The county clerk's office protects your private property rights as well as your real property rights, not through presumption that you're part of the corporation. Then we have to look at the coroner. Most of you don't realize, but the coroner is the only person who can arrest the sheriff. Think of that. That's our balance. Today is a special day here for Collier County. God has brought you to me, and I have brought you to God, because God will determine your future, not I. Thank you very much.
Matt?
The Constitution for the United States is the supreme law of the land, confirmed by Marbury versus Madison. All laws which are repugnant to the Constitution are null and void. Established in 1803. Think about this. How many legislative statutes violate the Constitution daily, all for generating revenue? Think about this. The sheriff, the city police, the tax assessor, all violating the Constitution. What is law? Black Law Dictionary, Volume 1, established in 1891, a system of principles and rules of human conduct. Black Law Dictionary, Volume 7, almost 100 years later. Time sure did change. A regime that orders human activities and relations through systematic application of force of politically organized society, or through social pressure backed by force in such a society, the legal system. Respect and obey the law. God-given rights versus government permission. Many people today have difficulty understanding the two. Unalienable versus inalienable. Unalienable are things which are not in commerce. In other words, the true living man and woman, where inalienable is of commerce, and it allows you to only have certain personal rights, as established in Black Law's Dictionary 4. By making each living body a corporation, government has created basically a twin, the living being versus the entity. What is a corporate name? Pull out your driver's license. Pull out anything that you receive that you have a commercial contract with. You'll notice your name in all capital letters. As defined in the Administrative Procedure Act in most states, it's brought forth through presumption. Letters of the English alphabet includes only uppercase or capital letters. There's no distinction between typeface or font that is recognized. So when you see your name in all capital letters, remember, you're not created by God anymore. You are created by government. Did you know you have two birth certificates? You have the de jure constitutional birth certificate, your true name, written in upper and lowercase, pursuant to law. When you have the second birth certificate, the de facto, the corporation, it's the recommended birth certificate, your name in all capital letters, pursuant to rule. Did you know that religion is under attack? Think about that. How many years has religion been under attack? The First Amendment to the United States Constitution prevents Congress from making laws respecting an establishment of religion, prohibiting the free exercise of religion. It was adopted on December 15th, 1791, as one of the 10 amendments. In 1954, Congress enacted the Johnson Amendment, which prohibits 501c3 organizations. In other words, a 501c3 for tax purposes, commercial tax purposes, including churches from endorsing or opposing political candidates to maintain their tax-exempt status. This amendment effectively limited the political speech of churches regarding candidates for public office. In other words, if you spoke out from a religious standpoint against a candidate or a political individual who was already in office, you would lose your standing. No longer a nonprofit organization. Seems like bribery to me, wouldn't you agree? The 14th Amendment was never ratified. U.S. Congress usurped the Constitution. June 13th, 1866, and usurped on July 21st of 1868, claiming to be ratified. Alabama, Arkansas, Florida, Georgia, Louisiana, Mississippi, North Carolina, South Carolina, Tennessee, Texas, and Virginia were all opposed to the 14th Amendment.
6 of the Confederate states, thus reconstructed, had ratified the 14th Amendment. Meanwhile, however, 2 northern states had changed their minds. Their sense of decency outraged by the monstrous procedures, the legislators of New Jersey and Ohio had withdrawn their former ratifications and had rejected the proposed 14th Amendment. This meant that even with the 6 Confederate ratifications made at gunpoint, there were not enough ratifications to meet the constitutional requirement that 3/4 of all states must ratify a constitutional amendment. But on July 21, 1868, Congress declared the 14th Amendment ratified anyway. This illegal appendage to our organic law has been used by the Warren Court in recent years as authority for decisions which, if permitted to stand, will complete the destruction of our republic. In the school segregation decision of May 1954, for example, the Supreme Court, using the 14th Amendment as its authority, assumed the power to change the meaning of the Constitution in order to make a decision which the court desired. In the Monroe case decision of February 1961, the court held that the 14th Amendment gives certain individuals right to bypass the normal processes of law in state courts and to bring cases against state and local officials directly in federal courts. Dissenting in this Monroe case, Justice Frankfurter said, the Supreme Court's decision completely eliminates the constitutionally reserved rights and responsibilities of all state and local governments. In the Baker versus Carr case of March 1962, the Warren Court held that the 14th Amendment gives federal courts power to control the apportionment and districting of states for purposes of state and local elections. This decision voided the laws of Tennessee, but 26 other states were also indirectly involved. This decision, giving the federal government power to regulate the composition and representation of state legislatures, makes state governments mere branches and tools of Washington authority. In the New York School Prayer case of June 1962, the Supreme Court used the 14th Amendment as authority to reverse the meaning of the First Amendment. Whereas the First Amendment prohibits the federal government from interfering with the free exercise of religion, the Supreme Court used the First Amendment, as reinforced by the 14th, as authority to outlaw the free exercise of religion. The destructive effect of these and other recent Supreme Court decisions will grow and multiply. The Constitution gives Congress authority to prohibit the court from accepting appeals in cases involving matters which, by the clear terms of our Constitution, are beyond federal jurisdiction. The public should strive to elect a Congress which will take such action. But even if this were done, we would still have the legal chaos which illegal Supreme Court decisions have already caused. Eisenhower's invasion of Arkansas with military force in 1957 and Kennedy's occupation of the city of Oxford, Mississippi, are fruits of the Supreme Court's decision of May 1954. A frightful number of public school systems in the United States have already eliminated all recognition of God in the classrooms as a result of the Supreme Court's New York prayer case decision. The most fundamental of states' rights, the right of representative government free of outside interference and domination, has already been abrogated in Tennessee by the 1962 Baker versus Carr decision and is threatened in 26 other states. Misinterpretation of the 14th Amendment, which is not a valid part of our Constitution, has caused such legal confusion as to render our system of constitutional law almost meaningless, even if the courts were restrained from further misinterpretations. Obviously, we need to eliminate the 14th Amendment and all the fruits of it. Get rid of the amendment and nullify all court decisions, executive actions, administrative regulations, and laws based on it. But how? Congress could enact a resolution proposing repeal of the 14th Amendment. But this would be tacit recognition that the amendment is now legal. Moreover, this vital question should be resolved not by some branch or agency of government, but by the people themselves. Congress should enact a resolution resubmitting the 14th Amendment for legal ratification or rejection. If the people want the 14th Amendment and all that it has produced, they could persuade 3/4 of the state legislatures to ratify it legally. I believe, however, that if given a chance, the people would tell their state legislators to reject the 14th Amendment. Large numbers of Americans are coming to realize that unless the 14th Amendment and all its progeny are abolished, we will not, no matter what else we may do, restore constitutional government in the United States. The meaning of constitutional government is that the government must be bound by the contract, the Constitution, which created the government. If public officials can change the Constitution, which they are sworn to uphold and obey, as they have been using the 14th Amendment as authority to do, then we actually have no Constitution. The law of the land becomes whatever officialdom wants it to mean on any particular day. We are at the mercy of a judicial oligarchy, which today can say that the Constitution and the laws mean one thing, but tomorrow can decide that they mean something else. That kind of chaos has already been created in our whole system of constitutional law by Warren Court misinterpretations of the illegal 14th Amendment. I know of no way to remove this confusion except by removing the basis of it, the 14th Amendment. This is a decision, however, that should not be made by Congress, but should be made by the whole people, acting through due constitutional process, through process as prescribed in the Constitution. Goodbye.
The United States, Inc., the District of Columbia, was established in 1871 within the boundaries of 10 square miles. The definition of de facto doctrine. The de facto doctrine is a rule of principle of law, which in the first place justifies the recognition of the authority of governments established and maintained by persons who have usurped the sovereign authority of the state and assert themselves by force and arms against the lawful government. Secondly, which recognizes the existence of and protects from collateral attack, public or private bodies corporate, which, through irregular and illegally organized, yet under color of law, openly exercise the powers and functions of regularly created bodies. And thirdly, which imparts validity to the official acts of persons who, under color of law or authority, hold office. The perception of truth. There's 54 United States of America and the political correctness of the corporate democracy. Special political contributions, politicians, lobbyists, private special statutes or color of law, agency rules and regulations, bureaucrats, the enforcers, people in servitude, subject to special proceedings where you are guilty till proven innocent. Violation of agency policy rules and regulations, special statutes, all to create revenue. What does federal mean? The truth was in front of you. As previously shown, federal pertaining to a league, derived from agreement, a covenant between parties, especially between nations, constituted by a compact. In other words, a contract between parties, usually governments or their representatives. What does league mean? League, criminal, law, contracts. In criminal law, a league is a conspiracy to do an unlawful act. Think about what we're saying, an unlawful act. What does conspiracy mean? The agreement or engagement of persons. In other words, more than one, to cooperate in accomplishing some unlawful purpose. In other words, to find you guilty before you're proven innocent, where you should be innocent until proving guilty, or to do any act with intent to prevent the course of justice, or to effect a legal purpose with a corrupt intent, or by improper means. Conspiracy is what is happening today in every city, county, state, and in our national government. The Chevron case was overturned by the Supreme Court on June 28th of 2024. This stops the interpretation of ambiguous statutes by all judges and administrative judges who have continued to violate due process, all to get a conviction to generate revenue with policy enforcement and control. In reality, there's no justice. Here we are with the state of South Carolina organizational chart. There are more agencies working than constitutional officers. When we look at the top of the chart, we see voters, not we the people. Voters are registered. Are you a registered voter? If you are, then you are a commercial entity voting for the CEO of the city, county, state, or federal election. Think of what we say. There's 19 agencies on the left, 14 in the middle, and 3 on the right. Altogether, there are 36 agencies. And agencies do not protect the Constitution. They all operate under what is color of law. Black Law Dictionary, Volume 2, 1910. The appearance, resemblance without the substance or legal right. Black Law Dictionary, Volume 7. The appearance, resemblance without the substance of legal right. The term USU implies the misuse of power made possible because the wrongdoer is clothed with the authority of the state. Remember what we said earlier, the Chevron case. USU is the rule of interpretation. Think of how many judges and officials that violate the Constitution due to their ego because they want to interpret the law according to what makes them look good or profitable, instead of protecting your rights, God-given rights, the constitutional rights that each and every one of us should have to be able to maintain our lifestyle and so forth. All enforcement officers and judge operate under commercial entities, subjecting the living man to commercial statutes as defined under 27 CFR 72.11, violating their oath of office while committing fraud on the record in every county, operating as a commercial business and bank. Did you know that the courts are a commercial business as well as a bank? They place bonds on each case. Send that money and paperwork to the Treasury and get reimbursed. You are a commodity. You're not a free living man or woman. Statutes, codes, rules, and regulations are not laws. They are rules for the government, not the people. Case law Cruden versus Neal, 2 NC 338, established in 1796, 2 SE. In 1934, the U.S. codes created Title IV, Section 112. Grants congressional consent from states to form agreements on or compacts for cooperative efforts in crime prevention and enforcement of criminal laws. This section allows states to establish joint and separate agencies to implement these compacts. Remember, contracts. The definition of states for this section includes all 50 states and the District of Columbia. Think of what we said earlier. 50 states, as well as the 4, Alaska, Hawaii, Puerto Rico, and the Virgin Islands, Guam, and the District of Columbia. This here is thought police, all administered through the agencies, as we shown earlier. There are more agencies than there are constitutional offices in South Carolina. You are charged with a criminal complaint or a civil complaint through your corporate name, your name in all capital letters instead of your true name. The Constitution of the United States of America in a courtroom does not exist. When we look at what has taken place, on the left-hand side, we have a republic form of government, de jure, our true constitutional government. United States of America, free men or women. We have a peace flag. Your name is in upper and lower case. It is considered your true name. Your true name binds you to a contract. Your sons and daughters, God's creation. We have freedom. We have gold and silver backed currency. When we look to the right, we have democracy, a form of commercial activity, de facto. You are a United States citizen. The flag is a war flag, maritime and law merchant flag. John Buck, Doe, your name in all capital letters, is a fictitious name created by government. You have child or children, a government creation, commercial servitude, fiat currency, credit, and debit. When you look under 1 USC, Section 8, person is defined as a corporation. When you look at vessel, 18 USC, Section 9, vessel is a citizen. In other words, you're on the water. 28 USC, Section 302, Section 4, you're a debtor. You're always in debt. Since 1933, the Securitization Act has placed all debt with the federal government. You're actually a cosigner, but you're considered the debtor. A person, 28 U.S. Code, Section 302.10. Again, you're considered a business. A commission, 28 U.S.C., Section 3002, 15B. Each and every one of these statutes that I refer to on the right place you in commercial servitude under the United States, Inc., through the District of Columbia. And it's all done with your birth certificate, the government trust, 31 CFR, Section 363.6. Again, who are you created in God's image? But government believes they created you and control you and violate your day, your life, your livelihood, all for money. Example, a driver equals commercial activity. Look it up under 49 CFR. South Carolina, your driver's license in all capital letters. Again, you're a commercial entity. A motor vehicle. The only motor vehicles, according to the regulations, are the ones shown before you. Vehicle configuration, cargo body type, etc. They're under the commercial status of government. You must operate a commercial vehicle. But when you're in the private, you're not operating in commerce. However, by getting that driver's license, you're registered, your name goes into the voter's box as a registered commercial entity. You're no longer the living man or woman or the son and daughter that you created. You are a commercial man or woman under the operation of commercial activity through your all cap name. Unconstitutional official acts. An unconstitutional act of an official will at least be a violation of the oath of that office to execute the duties of his office or her office, and therefore grounds for his removal or her removal of office. No official immunity or privileges or rank or position survive the commission of unlawful acts. If it violates the rights of an individual, it also likely to be a crime. And the militia duty obligates anyone aware of such a violation to investigate it, gather evidence for prosecution, make an arrest, and if necessary, seek an indictment from a grand jury. And if one is obtained, prosecute the offender in a court of law. What happened to our grand juries? Why doesn't the community come together with 25 people and another 25 people as backup and create grand juries to go ahead and come after these offenders who violate the Constitution? Why haven't we done that? Well, through fear, shame. We don't want to be put in that category. Oh, they don't want to follow our rules and regulations. They must be bad. The right to travel is a fundamental right. Here we go. Again, the Constitutional Foundation, Marlboro versus Madison. Anything that violates the Constitution is not a law. And as we look at each of these case laws on the left-hand side, it's very self-explanatory. Licensing only for commerce. Licensing applies to commerce only. Sims and adherence, private travel, not subject to regulation. Chicago Coach versus Chicago. Licensing applies for hire vehicles. In other words, you're just going down the road, go get your groceries. You're not being paid to drive. You're traveling. One of the biggest frauds that's placed on each man and woman living in the state of South Carolina and the other states within our country. It's actually RICO, a Racketeer Influenced and Corrupt Organization Act, codified 18 U.S. Code 1961 through 68. Though originally enacted in 1970 to combat organized crime like the mafia, it has since been used to challenge systematic fraud, corruption, collusion in both public and private sectors. The government is racketeering. I know that's a hard one to swallow, but that's the facts. Did you know by adding a different color or border to the U.S. flag, you have mutilated it? Every government building is in violation of 4 U.S. Code Section 3. You see, these flags with the gold fringes, this means the American flag is captured by the military or corporations, and they are illegal no matter what court you go into or where you see it. It means it's controlled by a military tribunal, corporations, business, private cult, companies, and basically a cartel. The U.S. flag is a very important flag. We have multiple styles of flags, even in the city, the county, and the state, all utilizing the gold fringe. Take the time and read this, for it's very important to understand that the District of Columbia is connected to each and every gold fringe through a compact, through a contract. Now we have the thin blue line, the red line, the green line, the yellow line, the orange line, the silver line, and white line. When we see our flag with these representations, it's a violation of our codes. You've mutilated Old Glory. It's not something that's neat. Personally, for all the veterans that fought, it's a violation of their self-sustaining ability to protect our country. Shame on each and every organization that flies these or wears them on their shoulder. The Boston Tea Party revolt started with taxation, government underbidding private industry. Think of it today. Think of all the taxes we have without representation. Everything from cigarette tax, food tax, hunting licenses, local income tax, Medicare tax, real estate tax, sales tax, septic permit tax, telephone tax, toll bridge tax, tunnel taxes, vehicle sales tax. Everything gets taxed. Where does that money go? Think about it. Here's a yearly example of what takes place in our country. So, United States population in 2023 estimated was 347.5 million. The U.S. illegal population in 2023 was estimated at 18.6 million. The estimate $150.7 billion given to illegals and non-citizens. Estimated $71.9 billion in foreign aid, etc. What every American is unaware of. So we're looking at 600 billion given away to non-Americans. No wonder our infrastructure has decayed. This has been going on every year for decades. Thank goodness we have the right president in charge to return us back to tariffs, where prior to 1913, tariffs took care of all taxation. The Federal Reserve is not a part of government. It sounds like it is, but it's all been a lie. The Federal Reserve System is a central banking system of the United States. It was created on December 23rd, 1913. And it was basically a session that took place with very few people in attendance. It was passed and cloaked during the eve of the night. With the enactment of the Federal Reserve Act, after a series of financial panics led to the desire of the central control of the monetary system in order to alleviate financial crisis, although an instrument of the U.S. government, the Federal Reserve System considered itself an independent central bank because its monetary policy decisions do not have to be approved by the president or by anyone else in the executive or legislative branches of government. It does not receive funding appropriated by Congress, and the terms of the members of the Board of Governors span multiple presidents and congressional terms. It's a private corporation that the monies go back to the Rothschilds, the 13 families that have controlled this world global financial system for centuries. We will see an end to the Federal Reserve System in this decade. I predict we could see the end of it before July 4th of 2026. Time will tell. The Federal Reserve is not part of the federal government. It is not a reserve. It is a private corporation owned by other private corporations. It has the power to create money out of thin air, loan it to the government at a high interest rate, which every living man and woman contribute to. The Federal Reserve is one of the last nails in the coffin to control the country through monetary and other means. What do these two patriots have in common? Donald Trump on the left, myself, BT on the right. We're both exposing the deep state corruption, the banking corruption, the agency corruptions, etc. One thing in common, we're both protected by God. This concludes our time today. Hopefully you've learned a lot. If you have any questions, feel free to write them down with the page number. And at our next open session, we'll answer all your questions. Once again, the NinthAmendmentParty.com, on the land for the United States of America. In God we trust.